Good evening.
Good evening. How are you?
Good evening.
Hello?
I can hear you.
Okay, good. I'll take the register now. I think we have more students now. You can just go ahead with your names, please.
Melissa Suggs.
Uh-huh.
Janice Stubbs.
Alicia
Yes, I
Wilson.
heard just in.
Mhm. Okay, I have Melissa Sands. Is Janice Stubbs?
Yes, Janice Stubbs.
Okay. DeAndrea Hutchinson.
Alicia Wilson.
Okay, Alicia Wilson.
Leah Lowe.
Leah Lowe. Okay.
Siobhan Kelly.
Okay. Okay, I have 6. So you have 6 students in this class?
I'm not sure of the amount, but I know Lavette is an
No.
exec.
Yeah, I think it's more.
Okay. Alrighty. So good evening again. My name is Denise Dorset, and I will take you through units 5 to 8. I think some of you were in a class before. We did a class together before, right? Some of you.
Yes.
Okay.
Yes.
Okay, so you know the format, we usually read through and then we answer the questions. Do you have any questions on your last unit or you're good? No?
No questions from me.
Okay. So we'll move on then. In this unit, we should understand the fundamentals of corporate record keeping, develop an awareness of the legal requirements of record keeping, gain practical insight into record keeping policies, procedures, and best practices, apply knowledge and understanding of corporate record keeping to trust administration, and discuss issues involving corporate record keeping. Before we move on Saturday, I doing my classes online. I don't know if that's an issue for anyone.
Not an issue for me.
Okay, so everyone is fine with online class?
Yes.
Yes,
Yes,
that's fine.
Okay. Okay, so we'll just continue on Saturday online. Now, who's gonna start the reading? You want me to just pick someone or you all want to volunteer?
I can read. Where do you want me to end?
You're
Or just
gonna
read the first page?
start with corporate record keeping.
Okay, sure. Corporate record keeping and maintenance is critical to the establishment of best practices in company and trust administration. Such tasks provide trust officers and trust administrators with accurate and updated information that may be used in key decision-making in the administration of trust and the discharge of a trustee's duties. It is important to keep and maintain corporate records for the following reasons. 1, to ensure limited liability protection for limited liability companies. 2, to ensure statutory, legal, and regulatory compliance. 3, to allow shareholders to be able to inspect corporate documents properly and adequately. 4, to fully document the shareholders, directors, and officers of a company and their due diligence information. 5, to represent current and accurate information on the company, its corporate and financial affairs and shareholding. Whilst the foregoing reasons do not comprise an exhaustive list, they do signify the practical need for effective record keeping and maintenance, particularly to minimize legal, regulatory, and compliance risks for failing to adhere to the minimum legal requirements of corporate record keeping and maintenance.
Okay, so corporate record keeping, we know is important and critical in order for us to properly monitor and be able to answer questions on trust under our administration. So we, first of all, the trust would have a holding company because of course the trust can't hold anything in its own name. So the company usually is underlying the trust, and in order for you to ensure that you're complying with the trust, what the trust parameters are, as well as what the company should be doing legally, we'd want to ensure that our record keeping is in order. So some of the record keeping, what comes to mind that you would need in record keeping with trust administration, what we should know about, what we need to have properly and adequately so we can be able to answer questions if it comes up. In relation to
The trust deed.
the trust deed. So we should have, so we'll have a trust file, eh? And our trust file will have what information, what we need to know readily available, what we need to know on our trust file.
The KYC documents.
Mm-hmm.
And I think that was Siobhan who said the trust deed.
Right, so what we need to know about this trust in order to be able to do any, to maintain and to be able to answer questions or to be able to do anything on the file, what we need to have, what we should have an outline of. Who are
We should be
the,
able to make decisions
right, who
Yeah.
can make
on
decisions?
behalf of the trust, the assets of the
Right.
trust.
And we want to know where the assets are
expenses.
because we may be responsible to ensure that things are upkept. What else?
The expenses, what's coming
Right.
from the trust and what's coming in,
Right,
income, capital,
and as far as the company is concerned, what we need to know.
The memo and arts.
Right. We should have, what else?
The directors and shareholders.
shareholders.
Mm-hmm. What we need to
The
ensure
certificates of
that-
good standing.
Right, so we need to
all that good
ensure that the fees have been paid like they should, and they're paid in a timely manner, because what happens if we don't pay in a timely manner?
The penalty is added to the company.
Right, and in the case of an IBC, what they do with them now?
Strike off.
Right,
Right.
so we want to ensure that that doesn't happen, because now you put everything in at risk when you do that, eh?
Yes.
And what else we need to do? Why are we keeping these records? In case what? Good right there. We want to make sure if the shareholders come, what happens?
They can inspect it readily.
Right. And then we want to make sure that if directors, we change directors, we upkeep our what? Would we keeping to know who are the directors?
Register.
Register.
Right, so if we change the directors, what we have to do? In a case of an IBC,
Well, you have to update the register. Huh?
right, and do what?
Oh, make sure it's filed,
Right, with what, where?
registry.
At the Registrar General's Department, eh?
Mhm.
And why do you think we need to do this? Because if we make the change, that's fine, eh? Why we need to do it at the Registrar General's Department?
Because that is on record of the change at the company. You need,
So when you, so
And it's
someone,
in our jurisdiction.
right, so if I'm a stranger to the company and I'm doing business, I should be able to go to the registry and have updated information on the company, right? So if you tell me, John Doe is signing these resolutions and I do a search at the registry and there's Jane Doe, who's still the director, and you didn't update the file to show John Doe, what happens? Am I going to do business with you with John Doe signing?
No,
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 No, so you have to ensure that your documents are up to date because most of these people are doing business offshore. And so they'll have people checking the records just like you would do in other jurisdictions. And you would want to ensure that everything is updated.
right.
So it has to represent current and accurate information on the company. That's what your filing should say, and its corporate and financial affairs and shareholding should be updated. So you should have your files in order. So your files should be properly laid out and updated constantly. And you should have a checklist in the front to ensure that you're keeping up with what you're supposed to do. So if there are any changes in shareholders, directors, that should be noted right away. And I should just be able to go into the file and look at the register and see when it was done, which day the person was resigned or removed, which day they resigned or they were removed, and which day somebody else was appointed. If the shareholders have changed hands, I should see how the shares were transferred. So if a new trustee took over, the company file should be updated to show the transfer from ABC Trust Company to UBS Company. Yes?
right.
Any questions on that? Are we mandated to file the register?
Yes,
Okay, so that's a legal and a statutory requirement, eh?
that's correct.
Okay. Let's continue. Who's gonna read next?
I can.
Thank you.
Corporate record keeping. Corporate record keeping for IBCs. With regards to IBCs, the International Business Companies Act 2000, as amended, requires the following. Section 37(1). An IBC must have a registered office at all times in the Bahamas. Section 37(2). The address of the RO must be submitted to the Registrar General with memorandum of association on application for incorporation of the IBC. Section 37(3). The directors of an IBC may change the address of the RO and notify the Registrar General within 14 days after the change has been made.
Okay, now these, these things are supposed to happen. I know sometimes they don't happen right away, but you see the deadlines they give you. So if you change the registered office, you should notify the Registrar General within 14 days. So that notice of change of registered office should be filed with the Registrar General within 14 days after the change has been made. So the resolution would say, ABC Company has changed their registered office from this trust company to another trust company, and that notice should be filed with the Registrar General's office so they can update the file. So if I'm searching the registry to see where this company's registered office is, it should be updated on the registry's file to ensure that it's showing where I can go to find out more information on this company.
Ms. Dorset, 1 second, and what happens in the instance where the registry records are not updated? Because just today,
Mhm.
I have, we wanted to pay some annual fees. And we noticed that online we were unable to pay using the Registrar General portal.
Mhm.
So we had the messenger go in to pay the fee, and we're not even the registered company.
Right, so that means that they've not updated the system. So it's incumbent upon the new registered office to
Mhm.
ensure that you not only file a notice, but it's updated in the system. So you should be able to follow up with them because they don't do it. I was just about to tell you that
Okay,
as much as people file the notices, it's not updated in the system. So it's incumbent upon the new registered office to ensure that it's done, because when they do a search online, I don't know if it's available anymore, but you'll see that the registered office, most of them are old in the system, and they don't go through the file to actually ensure when they get these notices that they updated in the system. So sometimes you have to ensure that your company's information is updated with the Registrar General's department, and you would have to bring that to their attention when you see it's not done.
okay.
Question, whose responsibility is it to make this update? The old entity or the new entity?
The new registered office, not the old one would want their name off, eh? So I
Mhm.
mean, as a matter of course, I would want you to make sure my name is off. So I'm not responsible now to file it. So if you don't do it, I will do it right away if I'm the registered office. But if you've done it, then I will just ensure that it's done. So that's just like if you purchased a house, you would want to ensure that it's in your name and not still registered in the name of the person who you bought it from. So you would ensure that your documents are properly recorded and updated in the system. So that's just the same thing. You make sure that this is a part of your corporate record keeping. You have to ensure that not only you have done your part, but you want to follow up that the registry has your information on file, because they having a lot of issues now with record keeping themselves. So you would find that you file in documents and they're still asking you for the same documents you filed. And then they saying you're responsible if they don't have it. So as much as you file it, you have their stamp on it. They don't have it and they're telling you will provide us with it. So you have to check your files sometimes, unfortunately. Okay, so we going on?
Continue.
Yes, please.
Okay. Section 38(1), an IBC must have a registered agent at all times in the Bahamas. Section
So that's
38.
important. You see that? The registered agent has to be in the Bahamas. The registered office has to be in the Bahamas. Unlike regular companies, the IBC needs to have a registered agent, and the registered agent has to be in the Bahamas. Okay, go ahead.
Section 38(2), a person cannot act as registered agent unless he is licensed to carry on the business of financial and corporate services pursuant to Section 3 of the Financial and Corporate Service Providers Act 2000 as amended. The section does not apply to a company licensed under the Banks and Trust Companies Act 2000 as amended.
Okay, so you can't act as a registered agent unless you have a financial and corporate service provider's license. However, companies that are registered under the Bank and Trust Companies Regulation Act, they are allowed to carry on this. They can act as registered agent. This section does not apply to them. So you would see some banks and trust companies, they operate as registered agent and registered office without a financial and corporate service provider's license. They can do it under the Banks and Trust Companies Regulation Act. But you cannot, the regular companies, you don't need a registered agent, but an IBC, you need to have a registered agent who is in the Bahamas and is licensed under the Financial and Corporate Services Providers Act, or they have to be a bank and trust company. Go ahead.
Section 38(5), the name and address of the registered agent must be submitted to the Registrar General for registration at the date of incorporation of the IBC.
So when you upload in your documents, that information has to be provided. What other information they ask you to submit on application for incorporation?
The memo and art.
Right, and what you have to put in there? What you have to give them, the address of who?
The registered agent, right?
Registered office.
Office, okay.
Yeah, so your registered agent's name, you have to submit that, the name and address, and you have to also give them the registered office's address at the time of incorporation. Okay, go ahead.
Section 39, the Registrar General maintain a register of registered agents.
Mhm.
Section 7 of the International Business Companies Amendment Act 2004, a register of mortgages and charges may be prepared and kept at the registered office. The IBC may elect to submit the register of mortgages and charges for registration with the Registrar General if I guess it decides to do so.
Right, so most of these IBCs operate offshore. And sometimes they get loans or guarantees or debentures in other jurisdictions. So these banks in the other jurisdictions would usually ask for a register of mortgages and charges to be prepared, and they want you to file it with the Registrar General's department and provide them a copy because they want their charge to be registered somewhere. So if someone does a search, they would know that this company has a loan with this bank in South Africa. And as much as they're operating in London, they've borrowed from us. So before you could come after this company, you have to first, we have a debenture over the assets of this company. So that's why they would want to make sure they do their register of mortgages and charges. The creditor would ask the registered office or agent to prepare it and file it and provide them with a copy. So it's up to the IBC to register that with the Registrar General, but the creditors usually demand that to be done in order for them to continue to do business with you. Okay, go ahead.
Similarly, to the Companies Act, companies, an IBC must maintain a share register at its registered office.
So as much as the share register is not public, you as the registered office must keep the share register at the office. So if the Registrar General or somebody would to come in to say, we need to see that you know who the shareholders are, they would want to know that you have the share register on file in your office. So you should know who the shareholders of your IBC, where you're the registered agent and office, you should know who the shareholders are.
So the Registrar General, that's the only entity who has the right to come and inspect it? I mean, other than like shareholders and whoever?
Well, you know, you may be called upon to, you may be audited as a whole. So say Central Bank comes to your bank and they audit in your files, they would want to see that you're in compliance with the IBC Act, eh? So if they're looking through your files and you don't have a share register on there, that's a red flag, and you would be cited, eh? That you don't have these things in place. So you're in contravention of the Act.
Okay.
Because now you're not doing your proper record keeping, and that's statute, eh?
Yes.
Yeah, so you have to, what section that is? What tells you that?
Section 29(1).
The next. Yes, section 29(1) says what?
An IBC is required to keep at its registered office one or more registered to be known as the share register, containing the name and addresses of persons who hold registered shares in the company, 2, the name of each class and series of registered shares held by each person. 3, the date on which the name of each person was entered into the share register. And 4, the date on which any person ceased to be a member.
Right, so your share register would usually outline the name, the address of the person. Sometimes you have what their occupation is. You would say their shareholding, what shares they hold, and if you have issued a share certificate, you would mention the number. And you would say how they're holding the shares, because sometimes these shares are divided into series A class, B class, or there may be series 1, A, B, B, something like or the other. So you would make sure you have to mention all those things if you have them divided. And you would say the day they became a member, and if they are no longer a member, you would also have a date to say when they resigned or transferred their shares. So that's what your share register would consist of, and it's in accordance with section 29(1), you should have it, eh?
Sorry. Section 29(2), the share register may be in such form as the directors may approve, but if it is magnetic, electronic, or other data storage form, the company shall be able to produce legible evidence of its contents.
So as much as you have it in magnetic form, electronic, or other data storage form, you should be able to produce legible evidence of the contents of the share register. I should be able to see what it was on the register. You have to be able to show me it in some form, eh? Go ahead.
Section 29(3), the share register shall be prima facie evidence of any matters directed or authorized by the IBC Act.
So on the face of it, all the evidence, the share register should be showing all of this information, who the shareholder is, when they came, all of that stuff as directed and authorized by the IBC Act.
Section
Okay.
29(4), where the IBC is limited by guarantee, the term share register shall mean register of members, in which shall be entered the names and addresses of the members of such a company, the date of such entry, and the date when any person ceased to be a member.
So where there is a share, where there's a company limited by guarantee, you don't issue the shares, you only guarantee in whatever amount the company has incorporated for you as the member. Now guarantee that up to that amount you would pay if the company were to fail. So just like with the shares, you would have paid up to the amount of shares you were issued. In this instance, they would only be limited by guarantee, the guarantee they give. So if they only guarantee up to $10, that's what you only can hold them liable for, up to $10, but their name should be entered into a register of members that way.
By law, an IBC must maintain a share register and register of directors and officers. Section 44(1), an IBC is required to keep a register of directors and officers containing the names and addresses of the persons who are directors and officers of the company, the date on which each person was appointed as director or officer of the company, and the date on which each person ceased to be a director or officer of the company.
So similarly, we'll have it set up like our share register, but in this instance, we now have a register of directors, and we only state in their name and address, the date on which they were appointed as a director, and the date on which they ceased to be a director. So you should have that outlined. And this now is the register of directors, which we will file to the Registrar General, with the Registrar General's Department. Go ahead.
Section 44(2), the register of directors and officers may be in such form as the directors approve, but if it is in magnetic, electronic, or other data storage form, the company must be able to produce legible evidence of its contents.
So again, as much as you have it in that, the format of electronic or magnetic, we should be able to produce it upon demand to see it, eh? You should have legible, it should be legible for somebody else to be able to read it.
Right. Section 44.4, a copy of the Register of Directors and Officers shall be filed with the Registrar General and open for inspection by the members of the company.
So now we know what section tells us we should have the directors and officers register filed with the Registrar General. That's section 44.4, and also section 44.4 says you should have it open for inspection by the members of the company, and that should be open for inspection where
At the Registrar General?
at the registered office, eh?
Yeah.
Because the Registrar General, we filing it there, so anybody could see it there, but if I want to come in as a member or shareholder, you should have it readily available for me to be able to see. Okay,
Under section 11 of the International Business Companies Amendment Act, 2004, the Register of Directors and Officers must be filed within 12 months of appointment.
so you have a deadline, eh? So you shouldn't, if you have already appointed someone, you shouldn't just be trying to file that 2 years later. You have a deadline of what?
12 months.
Yes, 12 months. So you think your penalty is for this?
Should.
Okay, let's continue to read.
Section 67.1, a company shall keep such financial statements, accounts, and records as the directors consider necessary or desirable in order to reflect the financial position of the company. Section 67.2, a company shall keep at its registered office a copy of the memorandum on articles and all amendments thereto, a register of all its directors and officers, and such other records as the minister may be order prescribed. Section 67.3, a company shall have a common seal and an imprint thereof shall be kept at the registered office of the company.
Okay, so these are things that you, as the registered office, must have in place if I come there to audit your books. Your companies that are under your care as registered office, you should have a copy of the memo and arts and all amendments made to the memo and arts, the register of directors and officers, and any other records as the minister may by order prescribe. So it's only if he makes an order. You should have a common seal. That doesn't have to be to the registered office, but what should be there?
The imprint.
Right, so you only have to make sure that you have an imprint of the seal at the registered office. And then you should also have financial statements, accounts, and records, what the directors consider necessary to reflect the financial position of the company at any given time. Go ahead.
Section 68, requirements for inspection of company records by a member or by attorney. Upon refusal by the company of a request, the member may, before the expiration of a period of 90 days of his receiving notice of the refusal, apply to the court for an order to allow the inspection.
So they can apply to the court where you've refused not to allow them to see the books. Are they able to see the books? Are there any laws that say they can see the books? To see the company records, any laws say that?
Yeah, that's section, is it 13 or 18? Would that come under the right to information or something like that?
No, look
Like
back,
the-
we
the
just
symbol?
read it.
Oh, section 67.
What we said,
Oh,
what we said about them seeing the members.
67-1. Yeah,
The member should be able to come into the office and review the documents for the company.
Right, where we said that,
67-1.
67-1, what 67-1 say?
A company shall keep such financial statements, accounts, and records as the directors consider necessary or desirable.
So
In
that
order
say
to-
anything about that the members, that gives the members something to come see?
Uh,
No?
I guess not.
Okay, what else we have? When we talk about, we talk about the register of directors. Remember, we talk about the registrar of directors being filed. (4404), remember that?
Yeah,
And
Yes.
what we say? Where the company member may inspect during normal business hours?
At the registered office.
Right, where that is, what section that is? We reading it,
That's section 44-4.
we reading it now. What we just read?
You mean the part where it's.
Oh, section 68.
Yes, 68 says the member can come and inspect the box, eh?
Mhm.
Yeah, so that's the section that gives them the right, and if you refuse, then they can go to the court. You're in paying attention to what we reading? I only asked you the same question. So section 68 gives the member a right to come and view the book, eh? Inspect their company records during normal business hours, eh?
yeah,
Okay. They want to see the share register, the books, records, minutes, and consents kept by the company and to make copies or extracts therefrom. And if they are refused, they can do what?
go to the court.
Right, they can now ask the court to allow inspection. They have a timeline to do this?
Yes,
What is that?
90 days.
Awesome. Okay. All right, let's continue.
The IBC Accounting Records Order 2016 requires IBCs to keep at its registered office a declaration stating that the company is maintaining reliable accounting records and the accounting records shall be made available to its registered agent.
So they have to prepare a declaration stating that the company is maintaining, so they only have to keep it at their registered office, eh? This declaration stating that the company is maintaining reliable accounting records and the records are available to the registered agent. They've made it available to its registered agent. So the company has to make that declaration. Each IBC,
Right,
okay? So that declaration should be made that the company has done these things. Okay,
okay. Section 181 imposes a fine of $10,000 or imprisonment for 2 years if a person who makes or assists in making a report, return, notice, or other document for submission to the registrar that contains any untrue statement of a material fact or omits to state a material fact required in such report, return, notice, or other document.
Okay, so section 81 now imposes a fine of $10,000 or imprisonment where you make statements that are not true, or you file returns or notices where you make an untrue statement of a material fact, or you omit a material fact that is required in the report or return notice or other document. So these sections now will help you in answering questions if someone were to ask you, this member wants to come in to see the books, which you could tell them now. Can the member see the books?
Yes, they can.
Yes, in accordance with what section?
68.
Yes,
Section
and now you have the directors of the company stating that why do I need to file a register? Why you have to put my name in the Registrar General's department? I thought this IBC is supposed to be confidential. Would you all answer them? In accordance with what section?
Section 37, 1 and 2.
We talking about the register of directors. Tell me what section I have to deal with. I want
44,
file a register of directors.
section 44.
Section
44.
44,
Section 44 tells you you have to do what?
2 and 4.
You have to file a register of directors.
Yes, a copy of the Register of Directors and Officers shall be filed with the Registrar General and open for inspection by the members of the company.
Excellent. And then if they tell you, if they have not given you the information, what you're going to tell them, you have a certain timeline to give me the say, I have to file this within what?
90 days.
Just the register of directors now, I have to file this within what?
12
12
months.
months.
Oh,
12.
12 months.
Yes. Okay, so you see how these sections will help you in just carrying out your work. Once you know that it's mandated or why you're doing it, these sections will guide you as to how you doing proper record keeping and the company keeping the corporate records. So it now applies with your trust records as well, eh? We should ensure that if any beneficiary has died, we have upkept, we will change that information, right? Yes?
Yeah.
We'll
Yes,
have
correct.
dates when dividends are due. If the company is to provide dividends, you should have that information there. That's financial aid.
Yes.
You should have who can make decisions on behalf of the trust. That information should be readily available. Yes. There should be at a glance that you can answer these questions. So if you have a question coming in from a beneficiary to say, am I able to get some shares or some dividend payment from this trust, or am I due for anything, which you can say, how you would know how to answer them. You'll have a cheat sheet. You have a cheat sheet in front of your trust files, eh? Yes? No?
Yes.
So
The
what?
cheat sheet being the checklist you mentioned?
Right, so the checklist will tell me, can this person ask for any payments to be made to them? Are they a beneficiary where I give, what are they income or capital beneficiary? What else I need to know about them? Are they a discretionary beneficiary? Are they a what type of beneficiary? If they're not discretionary, what they may be?
Non-discretionary.
Right, but
Fixed.
what, right, so we have a fixed beneficiary who's named, eh? And so what that means, they have a vested interest, eh?
Yeah.
So if they now ask for, they may be in my memo of wishes and the letter of wishes, it may direct me, or the trust instrument may say, Susie should get $25,000 on her 21st birthday. That information is important to be noted, That should be in the front there, so you know, that Susie's gonna turn 21 on June 2025. So that should come up, that should be in the front of your file, so you know that's something you need to know. This date is coming and fast approaching, Yes?
Yes.
So this applies in corporate, but we now have to apply it in the trust aspect. What about trust reports? Are the beneficiaries do trust reports? Do you have that outlined? They have portfolios. You have to check with their portfolio managers. They're supposed to send you in the dividends or whatever the trust should now be receiving. If the trust has an insurance policy, you have to ensure that it's paid up to date. If there are any cash values in it, all of those stuff. If they have jewelry, all these things, you should have information that you would know where assets are at a glance without having to go through all the documents every time. So you should have a sheet in the front to say assets, liabilities, protector, who can make decisions for investments, who are the beneficiaries, are they discretionary, and so forth and so on. Any questions? Chapter was clear?
Pretty much.
Mhm.
Okay, let's go on to the questions then. Number one, list reasons why it is important to keep and maintain corporate records. We will find that answer.
Page 53.
And what is that?
To ensure limited liability protection for limited liability companies to ensure statutory, legal, and regulatory compliance, to allow shareholders to be able to inspect corporate documents properly and adequately, fully document the shareholders, directors, and officers of a company and their due diligence information, to represent current and accurate information on the company, its corporate and financial affairs, and shareholder.
Okay. Number two, what information must be included in the register of member shareholders for an IBC Companies Act companies? Where we'll find that answer.
Page 55,
And what is it?
names and addresses of the shareholders, the number of each class of and series of the registered shares held by each person, the date the shareholder was entered in the register, and the date any shareholder ceased to be a member.
Excellent. Number three, with regard to IBCs, the person cannot act as blank unless he is licensed to carry on the business of financial and corporate services pursuant to Section 3 of the Financial and Corporate Service Providers Act 2000 as amended. We will find that answer.
54,
54.
And what is that?
section 38, a person cannot act as a registered agent.
Excellent. Number four, failure to keep a share register under the IBC Act is an offense with a penalty of a fine of blank or blank years imprisonment. Now, they didn't put this in here.
I
They
was
put
about to say, Ms.
Section
Ross, that
181.
I was about to say I had to go look this up.
Right, you have to go to section 180, which is right before section 181. And it gives you the penalty. So that's she put in the 181, but she didn't put in the section 180. So 180 will give you that fine. What is it?
$10,000 or 2 years.
Excellent. Number five, what information must be contained in the register of directors and officers for an IBC? Where we will find that?
On page 55 as well.
And what is that?
The name and addresses of the persons, the date they were appointed, and the date any person is no longer director or officer.
Excellent. Under section 11 of the International Business Companies Amendment Act 2004, the register of directors and officers must be filed within blank months of appointment. What is that? Where
Well,
we'll find it.
page 55,
And what is it?
under section 11 of the IBC Amendment Act 2004, the register of directors and officers must be filed within 12 months of appointment.
Excellent. Number 7, under section 7 of the International Business Companies Amendment Act 2004, a register of blank may be prepared and kept at the registered office. Where we'll find that answer.
54,
And what is that?
a register of mortgages and charges.
Excellent. So the only thing you have to now place in there is section 180, so you would know what the penalty was, 10K or 2 years imprisonment for failing to keep the records. And other than that, you just want to ensure that as much as you are keeping your corporate records, you want to say that you're keeping the trust records likewise. What is important for us to have legally for the trust? What we're supposed to ensure that the trust has what? For it to be legal.
It's the 3 certainties.
Sorry, repeat it.
For the trust, what we supposed to do when we get the trust? We supposed to have some stamp on it, eh? Yeah,
Yeah,
what the stamp is.
The company seal
No, we have to stamp
you
the
mean?
trust document.
or the trust document?
Right,
Was
so
it
this,
the imprint?
pardon me?
Was it the imprint?
No, this, no,
No.
I talking about the trust, not the company, because we have
Oh.
to apply the trust we have to apply corporate record keeping, also the trust record keeping. What we have to do for the trust? When we get the trust, what we have to do?
Incorporate.
stamps on it.
No, this
Stamp
trust
duty.
now. You all did trust already, right?
Yes, ma'am.
So what we have to do with the trust, and the trust have a stamping duty to pay?
Yeah, stamp duty.
What is stamp duty?
I
is?
I can't remember. I counting in my head how many stamps I put on the trust deed.
It's $50. It's $50. And what we do when we put the stamps on, how do we comply with the act? What we have to do with the stamp?
Make sure they can be used again.
So how we do that?
I write the date the deed was done on
Right,
it.
so usually you initial it, 2 of the trust officers or the officers of the trust company would initial it and then you would date it, eh? That cancels out it. That's how you
Mhm.
start off. What else we need to do? Because this trust record keeping now, because you have to apply corporate record to trust administration.
You have to make sure that it's funded.
Right? And how we fund it, what is usually the fund, what it is? We have a minimum they put in there?
I think $100 or something like
Yeah,
that.
they usually just start off with a little $100. Anything else we do? Would we say we need to know who, how, what?
So we need to know who is the settlor, the protector, if there is
Right.
one. And who the beneficiaries are.
And then we need to know how we should exercise, how, if we exercise in discretion, or if these persons already have vested interests. We should know which dates they supposed to get payments. We should know where their assets are, right?
Yeah.
And in that regard, what we have to do properly, what, supervise what?
I guess we have to keep a record of everything.
Right, so we have to properly supervise who? If you have assets outside,
Whoever's managing the asset.
right, so we can't just have the assets invested and we don't follow up and make sure everything is on track, eh? So
Right.
somebody should be following their portfolio, eh?
Yes.
Yes. Anything else we may be doing? If we have requests for payments or we have requests from the set law,
Trustee minutes.
right?
We
We should
keep
make sure our
prepared.
trust minutes in order, right?
Yes.
As to how we make decisions through our committees. Anything else? What about our finances?
Yeah, we gotta
You
keep those.
prepare trust reports?
You better.
Yeah, so that's a part of what you have to do, eh? You have to make sure you have trust reports done. So you know your financial position. Any questions on this chapter? Everybody was a little quiet. Or this chapter is pretty easy for you.
I don't think we'll ever say it's easy. It was just clear.
Excellent. Okay.
I just have a quick question.
uh-huh.
You mentioned $50 for the stamp duty, and a minimum of $100 has to be funded to like an account.
Now, it doesn't have to be a minimum of 100. It's what you fund, what you say your trust fund would be. Because some people may say I have a $10 trust fund, and they may have a lot of assets.
Okay.
So the stamp duty is what section you supposed to have a stamp on it? You all have that section? Y'all remember that section or no?
No.
67.3, a company shall have a common seal.
No. I know you asked them about this, the trust now, right? Or no?
The stamp duty.
On the trust instrument. So we
And
don't
then you
want to mix up company with trust now. I only letting you know you have to apply your company principles to your trust administration as well.
Okay. And then you mentioned that 2 officers have to initial and date.
Right,
Date-
so
and date what?
if you have a trust company, so let's just say we have UBS, I think UBS is closed now, so we could use them. We have UBS trustees. UBS would be an incorporated company. So usually you have 2 directors sign where there's a company, or you have 2 officers, the president, secretary, or you may have just directors signing. So you can't, there should be not one signature on behalf of a trust company. You should always have 2 signatures as mandated for companies on the whole. 2 should be carrying out business for a domestic company. And that's usually the companies that are banks and trust, or they are financial and corporate service providers. So you'd have 2 officers sign off on it, and you would date it. That's how you cancel out the stamp, and that's how you would now say that the trust instrument is now being properly stamped. So before the I think it was 1998 Act, you would have to traipse down to public treasury and have your documents stamped. Now you can do it in-house and you just cancel it out. That's clear?
It's okay.
So you've done a trust document where you had to do the stamping on it or no?
No, I'm not in trust actually.
Okay, so once you have a trust instrument, you have to put the stamp on it. So just like you would if you prepared an affidavit, just say, some affidavit of birth, you have to pay the government an $11 stamp in order for the document to be recorded and registered. That's the same thing with the trust document, but now it doesn't have to go through the public system. It's done in-house in the trust company, but they're supposed to ensure that the stamp duty is attached to the document. And this is important because if you ever had to take that document to court, if it's not properly stamped, it cannot be entered as evidence under the Registration of Records Act. You have to, the document has to be properly registered or has the duty, the stamp duty on, it has to have paid the stamp duty more than anything in order for the court to recognize it as a legal document.
I have a question.
Okay.
I just want, trying to tie trusts and companies together. So
Mhm.
because a trust isn't actually filed with the registry, is that the way that they not only get money, although it's nominal, just $50, but is that
Mhm.
the way that they officially make it legal? Like how we would have to file the M&As and we pay for that, and then we also pay to file the register of directors, which would be able to, you could get out of the registry. Is that kind of like the same?
Right, so
logic, I
then,
guess?
like you would pay, the M&A, they have the fees attached, they have all the duties included in the documents.
Okay,
The fees you pay up front. So you pay in the same stamp duty for the document as you would for a company, but it's just a nominal fee because it's not a public document.
okay, because I noticed that with a lot of documents to like be filed, like you mentioned, affidavit, like even immigration applications and stuff, you have to put a
Right.
$10 stamp on it. For the
Right,
duty.
right.
So,
So you have to pay the government the stamp duty on all of these documents. So
okay.
right down to an affidavit, you're not paying, I used to say $11 for. Now.
Can I miss Dorset? Sorry,
Mhm.
I don't know if you were done.
No, go ahead.
Okay, I have a question in terms of
Okay,
foundations.
I don't have you on the thing, sorry. Make sure I have everyone. Love
Hey,
that.
yes, ma'am.
Okay, good. All right, so I have
Um,
everyone. Let me see, 1, 2, 3, 4, 5, 6, 7. Okay, yes, go ahead, sorry.
Will we learn about foundations also in this class or not really?
No, they just brush on the surface. I don't know if it's in this one that you do.
Okay,
I know they just barely just brush the surface on that. I don't think they go into great details with the foundation. And I don't
okay,
see it being in this one unless you all would have gone over it before this class. It may
I
be in
just-
another, we did it in something else. If it's not in here, it's done in another trust course.
okay, because I know a lot of that has been popping up a lot lately on our end too, and it's like a lot of people don't seem to be that fully knowledgeable yet about it that much.
Right, because the foundations, that's a creature from Panama and Liechtenstein that the Bahamas wanted to incorporate here because it has some advantages, but because most persons are not so knowledgeable about it, they don't really fully utilize it. But a lot of the Panamanian jurisdictions, that's a big thing, foundations. They use those a lot, and I know they do them a lot in Liechtenstein as well. But I
Okay,
don't see it being so prominent here in the Bahamas. Because I
okay,
think you don't have persons who are knowledgeable about it, and they, as a result, they can't sell a product that they don't know anything about.
okay. Because I know it has an act as well.
Right,
So I'm
so
trying to
I mean,
understand.
and this has been in place for some time, but it's still not popular as yet. And that's
Okay.
because of lack of knowledge, I think.
Okay,
But
gotcha.
it gives a lot of leeway for founders and persons to be able to manage their accounts or their business without having to look at it in the light of being a sham. So that's what that was the idea behind it, but it's still not as popular here, I guess, because of you have to understand it a bit more.
Okay, thank you.
Mhm. Any other questions? So you all have an early night, I guess. Because we'll do 6 on Saturday. Is that everyone still here?
Yes, well, we start at 9:30.
9:30 is good on Saturday, yes?
Yes.
Yes.
Okay, so
Would we be
Yes.
using the same link?
yes, I think we'll use the same link.
Okay.
So 6 is a bit, we'll cover, 6 is a little longer, so you wouldn't get out as early. I guess they gave you all a Thursday night chapter, unit 5, and you get the bigger one on Saturday.
Okay.
Okay?
Okay.
Okay, so I'll see you guys on Saturday, God's willing.
Saturday at 9:30, correct?
Yes.
Okay.
Thank you so
thank you.
much. Take
All
care.
right.
Good
Good night.
Good night.